Well, hello everyone. Hello, and thank you for joining me. I am Lior Samfiru, the employment lawyer, and you are here live watching me, listening to me on my employment law session. This is the time where you get to find out about your workplace rights. This is the time where you get to ask questions and get those issues solved. So let's get that going. I'm Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. And I come here every week to do exactly what I'm about to do now, which is to talk to you about employment law, to talk to you about workplace rights, to make sure you understand what your rights are if you lost your job, to make sure you understand what your rights are if you're being mistreated in your job, what your rights are if your employer is doing something they're not allowed to do, if your job is changing, your pay, your compensation, your responsibilities. You get the idea. We have rights, you have rights in all these situations. And I'm here to tell you what they are and to help you understand what you can do if you're facing a workplace problem. It's not always going to be sunshine and roses in the workplace. There's going to be times when there's issues and problems. Well, on this session, we'll talk about the solutions that are available. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And this is the last time I'm going to be here on live stream this calendar year. Next time I'm going to be here, it's going to be 2025. So take advantage of me being here. Last few times I've been here, lots and lots of questions. I want to do the same thing today. I want to help you end the year on a positive note. By you understanding your rights, by you understanding what to do if you're facing a workplace dilemma. Now, I'm going to start answering questions right here in a moment. Before I do that, I want to give you some other information. If you want to connect with me and my team off social media, off air, very easy to do. Just go to employmentlawyer.ca. You see that address on the screen right now, employmentlawyer.ca. Phone number is right there. So is the email address, fax number if you prefer, or you can even fill out a form and my team will call you. It's all there at employmentlawyer.ca. And if, of course, once you're there, you can also read a lot more about your workplace rights. It's a great resource for you for anything and everything employment law. But that's later. Right now, I'm live. You're here watching me, so why not ask your question? You have a little box on the screen. You can type in your question, hit enter, and it's going to pop up on my screen. I'll read it and answer it. That's how simple that is. So let's start on that right now. Some questions have come in, but I want lots more. Okay, I want to be kept busy. I want to be kept hopping today. Again, I'm Lior Samfiru, the employment lawyer. Let's answer your questions about your workplace rights. First question in nice and early. This one is from Lynn. Lynn says, my employer terminated me after I made a complaint about disrespectful treatment. What should I do about this? Do I contact the labor board? Okay, well, first of all, what your employer did is illegal. You cannot be let go because you told your employer about being mistreated, whether it's bullying or harassment or a poisoned work environment. You're not allowed to be let go because of that. You are protected. The whole point of having laws is that you can't be punished for standing up for yourself. And you absolutely did the right thing. You told your employers you should have. What your employer must have or should have done in that case is to take it seriously, to investigate, and to fix the problem. And ultimately, regardless of what the conclusions were, they're not allowed to take it out on you, to punish you, or to let you go. So your employer did something wrong. That could be a breach of employment standards. Depending on the situation, that could be a wrongful dismissal. Depending on the situation, that could be a human rights violation. It's illegal. Unfortunately, labor board can't help you with that. Good news is, yeah, we can help you. We deal with this all the time. Even though I just told you it's completely illegal what your employer did, it does happen more often than it should. So we see this often. Give us a call. Okay, I want to talk to you. Let's help you potentially get your job back if that's what you want. But beyond that, get you compensation for the various violations that your employer committed here. So to connect with me, Lynn, easy. Again, I mentioned it before. I'm going to give it to you again. All you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. Very important lesson there for all the viewers. Your employer cannot punish you for complaining about workplace harassment. It's as simple as that. Most employers won't. Most employers will deal with it properly. If yours doesn't, like Lynn's employer didn't, call me. Okay, employmentlawyer.ca. Fantastic question, important question, one that I see too often. So thank you for that. See how easy it is, right? If you've just joined me, welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here live, answering your questions about employment law, your job, your workplace rights. This is the time, this is the place to ask questions. More questions have come in. I'm going to continue answering them. You got time, though. You got lots and lots of time. You don't want to run out of it, right? If you ask your question now, I'll guarantee you'll get an answer. Okay, so let's continue answering questions. Let's see. Next question comes from BE, and this is from Reddit. How late is an employer allowed to be with pay? I did not receive my pay during the last pay period and was told I will have to wait until the next one. Is this something an employer can do? Absolutely not. Not at all. They're not allowed to be late at all. You have an agreement with your employer. That agreement is very straightforward. You come in and do your job, and they pay you a certain amount of money on a certain date. That's it. Just like you can't decide you're not going to come into work, they can't decide they're not going to pay you when they're supposed to. Now, sometimes there's a payroll issue. Maybe you're sorry about that. Instead of tonight, we'll pay you tomorrow morning. Not appropriate, but okay, we can be understanding. But to say to you that you're going to miss your pay period, not acceptable. So the question becomes, well, what do we do about it? So for that, you can file a claim with the Ministry of Labor. You can get us involved. Usually once they get a letter from us, they'll pay you right away. That could potentially also be a constructive dismissal, meaning you may be able to treat the failure to pay you as a termination and get severance. So there's various options here. Remember, it is illegal. They have to pay you. It's not a nice to have. They don't get any discretion. It's very simple. The biggest obligation an employer has to you is to pay you the right amount on the right date. That's it. So, BE, if you want to connect with me to get working on getting this resolved, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. All the contact you need is right there. Sorry that that's happening to you, especially around the holidays, but reach out and let's deal with that. All right, another fantastic question. Gives you an idea of the types of issues that I deal with, something that may become relevant to you. But right now, you have an opportunity to ask the question. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live here answering questions. I see more questions came in. I'm going to answer them right now. As you're listening to me, type in your question as well, hit enter, and let me read it and answer it. All right, let's see. Red Crayon. Hello, Red Crayon is joining us and has a question. My wife's employer wants her to take a demotion and pay cut upon return from maternity leave. Wow. Does she just have to accept this? What can she do about it? The answer is no. It's illegal. They cannot do that. The obligation that they have is actually very, very straightforward. And that is when she's ready to come back from her leave, they have to take her back to the same job, same pay, same hour, same everything. That's it. It's that simple. They don't get to demote her. Okay, by the way, they wouldn't get to demote her and reduce her pay even in the absence of a leave. Even if she was just working, they don't get to do that. But certainly when she's coming back from a leave, when her job is protected, can't do that. Illegal. Human rights violation, potentially. Employment standards violation. Constructive dismissal. You name it, it's illegal. So what can she do about it? A couple of options. She can accept it if she wants. I wouldn't do that, but she certainly can. She can tell them, no, not doing it. Okay, sorry, I expect my old job, my old pay, and I'll see you when I'm ready to come back to work. No exceptions. They may back off at that point, in which case, no problem. If they don't back off, okay, if they say, too bad, we're doing it anyway, call me. Have her call me right away. Get this, once they hear from me, they're going to change their minds so quickly, your head will spin, okay, once we call them on this. So I would tell them for now, no, I'm not doing it. I expect to be back in my old job and my old pay, and that's it. If that's what happens, fantastic. If they say, too bad, we're not doing it, I'm right here. She needs to connect with me, Red Crayon, through employmentlawyer.ca. Again, employmentlawyer.ca. Why do employers do that? Unbelievable, right? Illegal. Well, at least now you know you have rights, you have options. It starts by reaching out to me. Again, Lior Samfiru, the employment lawyer, and I'm here to help. All right, thank you for that question. Let's continue answering. As you do that, by the way, I'm waiting for you to ask me your question if you haven't yet. Demonic Jedi, what a great name. Demonic Jedi has our next question. My employer says they don't pay holiday if I work on a holiday, only time and a half if I work, while other employees get a day off with pay. Could I refuse to work holidays because of that? So yes, you can absolutely refuse to work during the holidays. So that's up to you. If you work, yes, they do have to give you time and a half. If you refuse to work, you refuse to work. Any issues, if your employer is not doing something properly, for that you can absolutely go to the Ministry of Labor. Again, I've spoken about this before. Cannot go to the Ministry of Labor if you lost your job. You cannot go to the Ministry of Labor if it's a constructive dismissal. You cannot go to the ministry if a human rights violation has been committed. But what you can do is go there if your employer owes you money, vacation pay, overtime pay, holiday pay. For that, you can go. So that's a good recourse for yourself there, demonic Jedi, the Ministry of Labor. All right, thank you for that question. I'll continue answering questions. By the way, if you've just joined us, you need to know what is this? What are you seeing? Who are you seeing? Well, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin LLP, and I'm here once a week to answer your questions about employment law live. You get a chance to pick my brain, to get answers, to get solutions and help about all your workplace issues. So take advantage. I'm right here. Ask your question. Just like our next person up here, Brow P has our next question. The employer is telling me I have to change to a new shift. I have worked days for the last 3 years, but they now want me to work nights. This doesn't work for me. I have children. What can I tell them? So, very good question. So, the first thing I'll say is your employer does not have a right to make significant changes to terms of employment. So, if you're working days, they can't just say, too bad, now we decided to make it nights. That's a huge change. That's massive. So that is a constructive dismissal. So if they were to impose this on you, you're absolutely going to be able to treat this as a termination and get severance. But your situation is even more interesting than that. You say you have children. Presumably, you need to care for these children at night, so you can't be away. So they actually have to accommodate that. If they don't, not only is this a constructive dismissal, it's a human rights violation. So here's what you do. For now, I want you to send them an email, and I say email because it needs to be in writing, telling your employer, I can't do it. First of all, it's a big change in terms of employment. Second, I have children, I have responsibilities, and I cannot do that. I don't have other care available for them, so I need you to allow me to continue during days. If they back off, fantastic. If they don't, you call me. Okay, I can get them to back off. Okay, so you can connect with me. And I'll help you do that. First, send that email. Doesn't have to be long, 2-3 lines. If they allow you to continue days, you're golden. If not, you reach out to me before you do anything. Don't sign anything. Don't even say anything else. You can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Very easy to do that. Great question. And yeah, I understand completely why this would be a massive deal. It's a huge deal. But now you know better. So that's our strategy. Guys, before I continue, I see more questions have come in. I always like to take a moment during these sessions to tell you about another tool that's available to you. Another free and anonymous tool that you can use at any time to understand how much severance is owed to you. Okay? The amount of severance that's owed to you is not a week per year. It's not 2 weeks per year. It's not anything like that. For most people, it's significantly more. Okay, and people accept inadequate severance packages because they believe they're only owed a very small amount of severance. Don't let that happen to you. So how do you find out how much severance you're actually owed? Well, guess what? We have a tool for that. All you do is you go to pocketemploymentlawyer.ca. I'll give that to you again. It's on your screen too. Pocketemploymentlawyer.ca. And when you're there, you just click on our severance calculator. That's it. It's going to take you about 20 seconds. You answer a few questions, and you can find out how much severance is owed to you, the real amount, not the week per year nonsense. Not what the company's offering, what the law says you should have. Again, pocketemploymentlawyer.ca and click on the severance calculator. I mentioned it's free. I mentioned it's anonymous. You don't have to put in any names. You don't have to put in any phone numbers, credit cards, none of that. It's just there for you. It's a resource you can use if you lost your job and you're trying to understand whether what you've been offered is fair It's a resource that you can use if you're worried about losing your job and you just want to be prepared. And it's also a resource that you can use if you're just curious. I just want to know, what would I be owed just in case something ever happens? pocketemploymentlawyer.ca. Click on the severance calculator. I think some 2.5 million people across Canada have already used it. Be one of them. Check it out. It's there for you. Thank you for that. All right, let's continue answering questions. I'm still live here, still not going anywhere. You still have time. If you ask your question right now about employment law, you'll get an answer. I guarantee you'll still get an answer by the end of this session. So make that happen. All right, our next question comes from Pag. I was placed on a temporary layoff for 13 weeks. Today I received an email that I have two options: take a demotion and return to work in a different department, or extend my layoff until February. Are they allowed to do this? Well, those are the two options that they gave you. But there's a third option, which is none of the above. You may be able to consider this temporary layoff as a termination, as a constructive dismissal, and simply require the company to pay you severance. So that's a right that you have, by the way, anytime your employer puts you on a temporary layoff. In most cases, your employer does not have the right to put you on a temporary layoff. And if they do, you have that option, the option to consider that a termination, to say, I'm not okay with that. Think about it this way. If your employer came to you and said, I'm reducing your pay by 75%, you think that's crazy, right? Of course they can't do that. Of course they can't just decide to pay me 75% less. Well, what is a temporary layoff? A temporary layoff is not a 75% reduction. It's a 100% reduction. They're not paying you at all. Well, guess what? Your employer can't do that. It's a constructive dismissal. So for you, Pag, what do you do here? Well, if you want to pursue a constructive dismissal, you can do this now. Say, thank you, but no, constructive dismissal, I don't want to do any of that. If you don't want to pursue a constructive dismissal, well, I guess your only options is to accept one of the two possibilities they gave you. Either take a demotion or extend your leave. I wouldn't do either of those. Remember, if you accept what they've done, if you go back to work now after a layoff, by accepting it, you've given the company the right to do it again. I just told you, in most cases, your employer does not have a right to put you on a temporary layoff. But if you accept it, you give them that right to do it again and again and again. You really don't want that. So whenever we're dealing with a temporary layoff, I find that in most cases, your better option is to treat that as a termination and get your severance. So that's ultimately what I recommend. Of course, you can't do that, shouldn't do anything until you reach out. Let's discuss. Let's make sure we do this right. To connect with me, very simple, employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic question. Temporary layoffs. A lot of people are surprised to find out, to hear that, no, your employer does not have a right to do that. They don't. They don't have a right to just say, we're going to stop employing you for a bunch of time. Can't do that. Okay? So that's a constructive dismissal. If you've just joined me, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin LLP. And as you're seeing, I'm here live answering your questions. Ask yours. I see more have come in. I'm going to answer them right now. You got time, so ask your question as well. Another question from Reddit. This one is from Biln. Biln or Bin. Either way. Can my employer refuse to accept my 2-week resignation? I recently gave notice to my job, and my employer said that unfortunately, I needed to submit my notice a month prior. Can they just refuse this and force me to continue working? Well, think about it. How are they going to do that? Are they going to lock you in a room and threaten you with baseball bats? Are they going to come to your house and force you into a car and drag you to work? Obviously not. So the question is not, can they force me? The question is, do you actually have any obligation to provide them more than 2 weeks? Well, the first thing you look at is your employment agreement. Did you sign an employment agreement, and does that employment agreement say you should give them a certain amount of notice? If your employment agreement says 4 weeks, you should give them 4 weeks. That doesn't mean they can force you to continue working, but it means that that's what you've agreed to give them. If your employment agreement does not speak to the issue, or you don't have an employment agreement, then you're required to give them a reasonable amount of notice. What is reasonable is different in any situation, depending on the type of job that you have, depending on the time of year, depending on the responsibilities that you have and how difficult it's going to be to replace you. So I can't answer that. But in terms of can they refuse? No. They can ask you for more notice, but they can't lock you in and then, beat you up. So that's the answer there. Hopefully that makes sense. Any follow-up, easy to do. You can just reach me through employmentlawyer.ca, and happy to have a private chat or private email exchange. Same with all of you watching. You want to reach out to me, you want to connect with me or my team and have a discussion beyond just this live stream, easy. Employmentlawyer.ca, phone number, email, everything you need is right there. All right, fantastic. More questions have come in. I love it when questions are coming in. You still have a few more minutes to do that and ask your question and get it in so that I can answer it before the end of the session. Just like Borderlines has our next question. Just let go after 8 years working in sales. Got the chop right before our annual commissions were issued. Offered 4 months. Am I SOL for getting paid for the work I did this year? So first of all, before we even talk about commissions, we have to talk about the number of months that they owe you. So you're in sales, you've been there for 8 years. I don't know your age, but I can tell you, you're going to be owed more than 4 months. It could easily be 2 or even 3 times that. Probably 8 months, 9, maybe even 12 months, especially if you're a bit older, it could be 12 months. So right off the bat, this is a wrongful dismissal. It's a wrongful dismissal because you're owed more than 4 months. Beyond that, if there's money owed to you on account of work that you did this year, they have to pay it to you, even if you're not physically there when they were going to write the check. So no, they don't get to pick a convenient termination date to avoid paying you for money that you've earned. So no, Borderlines, this is a wrongful dismissal. They owe you compensation. You're not in a position to accept that because you're owed much more. The good news is we'll be able to resolve it. I guarantee you we'll be able to resolve it. So what you need to do now, as I said before, just reach out, okay? Reach out to me, my team, through employmentlawyer.ca. Again, employmentlawyer.ca, and let's have a chat. And I mentioned before, if you weren't here, Borderlines, to get an assessment of the amount of severance it's owed to you, just go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Click on the severance calculator. Answer a few questions there and find out just how many months you're owed. Spoiler alert, much more than 4 months. Okay? So that's the answer there, Borderlines. You know now what to do. You know how to reach me. Again, employmentlawyer.ca to do that. I'm looking forward to speaking to you ASAP. Don't sit on this, okay? All right, fantastic questions. I'm Lior Samfiru, by the way, the employment lawyer, Samfiru Tumarkin. And let's continue answering questions. If you want to ask yours, what are you waiting for? Session's going to be over soon. Now's the time. No later, right now. And I'm not going to be back here on live stream till after the holidays. So let's make sure you get your question answered now. Stephen has our next question. I got laid off in the summer after being employed for 2 years. They told me they had a shortage of work and had to let me go. I have coworkers who are still working there. Can I pursue any legal action here? Well, here's the thing, Stephen. The issue is not that they let you go. Even if they were lying about the reason, they're allowed to let you go. Even if we don't agree with the reason, even if they lied about the reason, they're allowed to let you go as long as they pay proper severance. So the question is not why did they let you go and why coworkers are working. The issue is, did they give you proper severance? Now, you've been there for 2 years. I don't know the type of job that you have or your age, but you could easily be owed 3 months, 5 months, even 6 months of severance, depending on your age and the type of job. So if they paid you proper severance, it's fine. I bet you anything they didn't. My hope is you didn't sign something. If they offered you something and you signed it accepting it, you may be unable to pursue this. If you did not, now's the time to reach out to me. Let's get you that severance. So I often get contacted by people that are upset for good reason. I understand why, but they're upset that they've been let go. And what I have to tell them is, from a legal standpoint, the fact that you were let go is not really the issue in most cases. The real issue is severance. And that's why you hear me talk about severance so often on these sessions, because from a legal standpoint, often that's what matters. So, Stephen, you know what to do. Reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. Borderlines had a follow-up question. Borderlines was fired before commissions were owed. Would they get in trouble for acting shady, like for firing before they have to pay commissions? Potentially. But let's not even worry about it. Let's get you what you're owed, okay? Yeah, if they're trying to avoid paying you money, that could be bad faith. It could be other compensation. But I just told you could be owed 2 or 3 times what they've offered you, plus whatever commissions are outstanding. I think that's enough of a reason to pursue this, right? So again, employmentlawyer.ca to connect with me. All right. Let's see. Renee French has our next question. How difficult is it to prove misclassification if the company made you purchase a major piece of equipment, such as a delivery truck, but everything else is an employee relationship? It's not difficult to prove misclassification. In most cases, it's pretty obvious, okay? So if you purchase a piece of equipment, but everything else looks like an employee, you work for them exclusively, they tell you what to do, where to go, how many hours you're going to work, they control all of that. You are their employee. It doesn't matter. And in most cases, it's quite straightforward to figure that out. And if you are an employee, you've been misclassified as a contractor, but you really are an employee. What does that mean? Well, a few things. Number one, it means you're owed vacation pay, overtime pay, minimum wage, holiday pay, because employees get that. But it also means that you're owed severance if they let you go. So what I see very often in situations where someone has been misclassified is the company that they work for says, we're going to let you go, but because you're not an employee or a contractor, we're not going to pay you any severance. Well, no, I've been misclassified. I am an employee. You called me something else, but I'm not that. I'm actually an employee. Therefore, severance has to be paid. So no, it's not difficult, Renee. And yeah, by the way, let me tell you how you find out right now for all of you as well. I mentioned the Pocket Employment Lawyer tool. You'll find that at pocketemploymentlawyer.ca. One of the things that it does is it allows you, we have a tool there that assesses if you've been misclassified. It assesses whether you're an employee or an independent contractor. So just click on that employee contractor tool, answer a few questions, and it's going to give you an assessment right there and then for free and anonymously if you're an employee or a contractor. Hopefully that makes sense, Renee. You know what to do if you need me. Just go to employmentlawyer.ca and let's have a chat. All right, last question of the day, I think. This is on YouTube from David. I have worked for a company in management since 1996. They were going to be bought recently, but the deal fell through. I sense ownership may just shut it down. I believe I'm entitled to a minimum of 8 weeks pay, but I'm wondering if I should be receiving more or I will get anything if they shut down. First of all, you're owed a heck of a lot more than 8 weeks pay. You've been there for, 18, 19 years. You could be looking at anywhere from 18 to 24 months, not weeks, months of severance right off the bat. If they shut down, yes, they have to pay severance. The only time a company may not be able to pay severance is if they're formally in bankruptcy proceeding, formally. But no, if they decide to shut down, absolutely doesn't relieve them of those obligations. They have to pay you severance. Bottom line, if you lost your job, are losing your job, if they told you you're about to lose your job, contact me as soon as possible, employmentlawyer.ca. Let's squeeze another one here. Marsha just came in with the question. My employer told me when they hired me, they were going to transition me to another role, but they are now backtracking. And if I don't want the old role, they don't have a job for me. What can I do? Well, if you have some proof that they told you, or they acknowledge that they told you that you're going to have a different role, and if you don't want the current role, they'll have to let you go with severance. Now, that's only if there's proof, if everyone agrees that you were promised that role. If there's no proof that you were promised that role and you don't want the current one, that's a resignation. But if there's proof that you stayed on because they told you there's going to be a different role, now they're not doing that, well, you can refuse, and that could potentially end up being with you being owed severance. So you have to decide what is better. Is it better for me to stay in the old role, or to leave with severance? If you want to leave with severance, you know what to do. Reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, lots of questions came in today. I love it. This is the time that I have for today. Thank you so much for joining me. As always a pleasure and a privilege to be here to answer questions and hopefully make you feel better, alleviate the concerns you have about employment law. I'm going to take this opportunity, of course, to wish all of you happy holidays, happy new year. Please be safe and healthy during this holiday season. Enjoy it. Spend time with family and friends. And I will be back here after the holidays, but I'm not going anywhere. Okay. If you want to reach out to me or my team, even now, even during the holidays, easy to do. Just go to employmentlawyer.ca, employmentlawyer.ca, the place to go. Thank you again, everyone. Have a happy holidays, and we'll see you here in 2025. Thanks.